Welcome, ladies and gentlemen, to the World Intellectual Property Forum. My name is Kandiah. I am from the firm KASS International, based in Kuala Lumpur, Malaysia. I'm here today to share with you the experience of the law on intellectual property rights in the ASEAN countries. Now, I've named this topic is Bay of Bengal, beyond the Bay of Bengal, because beyond India lies the Bay of Bengal. And beyond Bay of Bengal lies collectively a big and vibrant community, a vibrant world, where there's a wealth of opportunities for Indian business people. Let's look into that. Now let's look at intellectual rights in the ASEAN countries. Now, before I go into that, I think for those of you who are uninitiated, let me share with you who are the ASEAN countries. The word ASEAN means Association of Southeast Asian Nations, comprising at the moment of 10 countries. As you see in the slide Malaysia, Singapore, Indonesia, Vietnam, Thailand, Myanmar, Philippines, and Brunei. Almost all these South Asian countries are members of this economic community, ASEAN community itself. And ASEAN itself is collectively the third largest economy in Asia. It is also the seventh largest economy in the world. And by 2036, it is the population, the total population of 673 million, which is about half the population of India, and the GDP of $3.11 trillion. So it's a very significant economic community which India cannot ignore. Now, the ASEAN Economic Community is modeled after the European Community. That is the intention of the ASEAN countries, to have an economic community modeled after the European Community. And they intend to create a single market offering opportunities in the form of a huge market of $3.1 trillion, covering 673 million people. And the key features, as I said earlier, is based on the European Community, a single market, production-based and highly competitive economic region, in a region of equitable economic development and fully integrated into the global economy. Let's get into the details. Now, at the moment, the areas of cooperation among members is still work in progress. These are some of the areas that the ASEAN countries have already started working together. Areas of cooperation, the human resource development, the recognition of professional qualifications. For example, in terms of recognition of professional qualifications, Malaysian lawyers who are admitted to practice in Malaysian bar can easily get admitted to practice in the Singapore courts. Similarly, trademark agents in Malaysia can easily be registered, practice trademark registration at least before the Singapore IP office in Singapore, similarly for patent agents as well. And this approach of recognizing professional quality of countries is spreading throughout Asia. This still, as I said earlier, this is still work in progress. In a matter of time, all this will be harmonized, and for professional one country can easily obtain recognition or registration in other ASEAN countries. Okay. But let's look at the IP rights in the ASEAN countries. Now, although I said they're trying to form a European community, but we're still far from there. The question rises, is one single registration, is it enough to cover all the ASEAN countries? For example, in Europe, to obtain a trademark in Europe, you register one registration in Europe, in Alicante, and that covers community mark in all the European countries. And similarly, for patent registration in Europe, you file one registration in the European Patent Office, and once it is allowed, you just need to validate it in all the other European countries. In ASEAN countries, no, it's still the old system where you need to register in each country if you want rights, IP rights in each country. But the countries are working together towards a common registration system. But that's still a long way off. So at the moment, it's country by country registration. Of course, there are some cooperation in some areas. For example, the area of patent prosecution. Countries have got together and they have the system known as ASPEC, where patent examination in one country, in the first country of first filing, can be used to expedite the examination in another ASPEC member country. So that speeds up the time taken to process a patent application at a patent office. So this is one example of joint cooperation. And for trademarks, not yet. Trademarks claiming priority and all that, it is still under the old system. We claim priority applications under the Paris Convention. Now, these are some of the important international treaties which members are acceded to. You notice from the slide, all the countries except Myanmar acceded to all the international treaties, namely the Paris Convention, PCT, and Madrid Protocol. Myanmar is a latecomer into the field. In fact, it was a latecomer into the ASEAN treaty itself. And they are still in the process of enacting new laws and so on. But with the recent uncertainty in Myanmar, things have been put on hold. The IP laws in Myanmar, as we shall see later, it is still not totally complete. In some areas, they have enacted new laws. In other areas, it's still bound by the old laws. As I've mentioned, all ASEAN countries except Myanmar have the basic IP laws in force. Myanmar's new IP laws were recently enacted in 2019 under the earlier government, but now under the present uncertainty there, things are put on hold. Generally, the ASEAN countries, Malaysia, Singapore, Brunei generally adopt the British legal system, adopt the common law doctrine, okay? Just like in India. But countries like Laos, Cambodia, and Vietnam generally follow the French legal system. Okay? Thailand maybe follows similar to the US system. All these countries have different systems, and handling IP rights in a variety of countries can be confusing and difficult for foreigners, especially if they don't use English as a main language. Now, all these applications, all these countries have to be filed in their local languages. For example, in Indonesia, you have to file it in the Indonesian language. In Thailand, it's going to be the Thai language. And in Myanmar, you have to file in the Myanmar language. In Vietnam, it has to be translated to the Vietnamese language. Now, this creates a lot of problems and challenges for foreign IP holders. This is where KASS comes in, and KASS has solved the problem by having one-stop center. Now, KASS has a more than 20-year-old firm. The head office is in Kuala Lumpur. We have our own branch office in Singapore, Indonesia, Myanmar, Thailand, and Vietnam. And it's a one-stop center. We handle all the applications in Kuala Lumpur. We handle the translation, filing of the applications in any of these countries. Okay? So one-stop center to handle all the any of these countries, all the ASEAN countries. Now, one of the problems I face from my own personal experience from Indian producer of consumer goods that they have sometimes ignore the importance of IP rights in these countries. Let me give you a simple example. I have a simple product here. This is just a bar of soap, which you have from the local shop, bar bathing soap, imported into Malaysia, export from India, imported in Malaysia. But surprisingly, the trademark is not, this product is not registered in Malaysia. It was registered a long time ago, it's since expired. So technically at the moment, this product, the trademark is not registered. As IP practitioners, you'll know that if it is not registered, it's very difficult to take infringement action against parallel importers, against counterfeits. Same thing applies in all the other countries. Malaysia is a big market, and then from the point of view from IP practice strategy, I think it's sad to say very few of the Indian firms have a strong strategy, a strong procedure to handle this. For example, the marks registered and it's not been renewed. And again, when it comes to marketing of this product, although this product appeals to generally Indian customers of Indian origin, but the product has been marketed for such a long time. And this product, generally this product, but generally Ayurvedic products coming from India, are generally well received by other communities, namely the Chinese and the Malay communities. But yet the Indian manufacturers or the producers do not aim to reach that market. They restrict themselves to the Indian market, which is small. The Indian population is very small, and they only try to cover that market. And the distribution channels are again restricted to outlets owned by Indian businesses, which is a very narrow outlet. Now, if the product is well received by the general Malaysian community, then the country should take steps to have different distribution channels so they can reach the general public. So by ignoring that, the manufacturers or the producers of these products, especially Ayurvedic products and consumer products in the food industry, are missing out a large percentage of the market in Malaysia. Now let's look at some updates in Malaysia and Myanmar IP updates. Let's look at trademark in Malaysia first. Now, Malaysia has recently amended its Trademark Act to give you expanded scope of protection. It's now possible to register the non-traditional trademarks, namely sound, shape marks as well. And it's also possible to file multi-class applications in one application. Before that, it was class-by-class application. Now it's possible for a single application to include multi-class that reduces the cost of registration. There are also changes in the prosecution process, scope of enrichment. Another interesting issue is that trademarks can be now considered as collateral security for bank loans and so on. And this advantages to Malaysian trademark owners, because now with a registered trademark, you can approach banks and use your registered trademark as collateral for financial assistance from the bank. Now let's look at the patent point of the patent law. Malaysia has again amended the Patents Act. It is now going to accede to the Budapest Treaty for the international deposit microorganisms and so on. At the moment, we're not members of the Budapest Treaty, but the Patent Office does recognize deposit microorganisms in some internationally recognized what they call depository laboratories. Another important thing is the amendments made to the Patents Act. It's possible now to amend patents during the court proceedings. And amendments done to incorporate Article 31 based on the TRIPS agreement in respect of compulsory licensing. Now, earlier, once a patent application is filed, there's no opportunity for third-party observations formally. Although informally, third parties can provide details of the some prior art documents to the examiners and request them to consider the prior art documents in the substantive examination. It is a very informal practice. Now that practice now has been formalized, where now it is possible formally to file third-party observations during the examination process. This is to enable the examiners to consider prior art documents, which maybe the examiners may not have considered the whole examination. And secondly, it's possible to now have post-grant opposition. Before this amendment, any granted patent has got to be challenged in the court of law after grant. Now it's possible to have post-grant oppositions before the patent office, thereby reducing the cost of invalidating a patent, the cost of what we call challenging a granted patent. And as like trademark, it's possible now to monetize and securitize the patents formed as collateral for bank loans. How this is going to roll out is still uncertain. We don't know to what extent the banks are going to accept these patents as security for loans. Yet to be determined, but it's all in the development stage. And actually, Myanmar, as all aware, has undergone radical change in 2020 with the military government taking over. But the previous government had enacted new laws. They've enacted the industrial design law, trademark law, and patent law, and also copyright law. So those have all been suspended, not come into force yet. Now let's look at a trademark. From our perspective, we find there's a lot of interest in filing or seeking trademark registrations in Myanmar. Under the earlier system, there was no proper registration system for trademarks. The applicant has to just fill up a form and file the trademark as an asset before the Register of Deeds and Titles, just like registering a land title. Now, the laws were amended where they receive applications, examine it, and grant, like in other countries. And to encourage the owners of trademarks, the government's introduced a soft opening system launched for recording trademarks. So existing trademark owners may re-register the applications under the new law during the soft opening in order to maintain the protection of the trademarks under the new law. Now, when was the soft opening launched? It was launched last year in the previous government from 1st October 2020. It was government promised that soft opening will be kept open. The initially is fixed at this date and this year, but now since of the uncertainty in Myanmar, they extended the soft opening until further notice. So those Indian traders who are looking at registering their trademarks in Myanmar should consider taking advantage of the soft opening, register the trademarks under the new law during the soft opening period, where it's easier to register a trademark under the soft opening rather than wait under the old laws. Myanmar unfortunately adopts a first to file rule rather than a first to use rule. Now, trademark registration is valid for 10 years, like any other countries, renewable for every 10 years. The country is also introduced recognizing well-known marks, but the Act is not clear what is a well-known mark. That's yet to be called a regulation. And at the moment, it's possible to have opposition cancellation actions before the trademark office. Myanmar has established a new intellectual property office, rather than depending on the office of the registration of deeds and titles. So this is called a positive improvement or advancement in the Myanmar intellectual property rights regime. Now, as far as patent rights are concerned in Myanmar, there's no proper patent regime system. This is the old law where the owner of a granted patent in some other country only publishes a cautionary notice, warning notice in public papers. It serves as a notice to international infringement. In case there's infringement, then to initiate court action. And the court will decide whether there's infringement or not based on the granted foreign patent. But under the new law, they will have a proper examination system and so on. So this is still work in progress. We have to see how the law will develop as far as patent rights. The trademark rights is very clear. Now, for copyright, there's no revision proceeding. But anyway, copyright will come under the Berne Convention. So Myanmar will be governed under the Berne Convention. We take action for copyright infringement in the Berne Convention. That's all I have to say for you. If you have any particular question, any particular aspects, feel free to send me an email and please do answer your queries. Thank you.